Right. I had a few questions here about some debt collection stuff and things. So I just wanted to go live and answer some of these questions. So if you're here and you're watching and you've got any questions that you want to drop them in the chat. I'll try and answer them. I'll be here for a few minutes. So yeah, if you've got any questions, happy to answer those. So again, my name's Greg. I'm a lawyer. I run Debt Brief and just trying to answer some questions that I've got here. So first question that I have is, so I've been sued for a debt and my, but they did not serve me with the summons. They served my wife. Does that mean that service is not effective or that they haven't sued me? So basically, to give a little background on this, first, you're going to need to know that typically they're going to have to personally serve you if service is going to be effective. That means that they actually have to, in most cases, someone has to physically hand you the summons and the complaint. And if they don't do that, then they really haven't had effective service. And so they really shouldn't be able to get a judgment against, debt collectors are going to lie about this. I've seen it before. They'll say they've done it when they actually haven't, but they're supposed to, right? So that means like they can't send it in the mail unless it's the kind of mail that they have to, that you've got to sign for. So if it's certified and the mailman comes to the door and you sign the paper, that's oftentimes effective service. But if and obviously if they have like a process server come to your door and hand it to you, that's going to be effective service. If they come and just like tape it to the door, in most cases that's not going to be effective service. It means they haven't adequately served you with the summons. They need to do it again. Likewise, if they just send it regular mail, that's not going to be effective either. So the question again is, so what if they have not served you, but they've served your spouse or they've served someone else that lives at your house? Now, the rules and the laws on this are going to be different for every state. So you need to look up the law specifically in your state as to what actually accomplishes service. But in most cases, they've got to physically serve you. But, and a lot of times there's rules that if they serve an adult that is living in your house, then that is effective service. The idea being that, look, we want to make sure that people are aware that they've been sued. We want to make sure that there is human-to-human contact so that you know that you've been served with a summons and complaint. And if you have not been served with a summons and complaint, or if it's been taped on the door, we can't guarantee, and we want to make sure that people know that they've been served. But I think what the law assumes then in most cases is, look, we serve a spouse, that spouse is going to let them know that they've been served. They're going to pass that along. So I guess the answer to the question is, if they have served the summons on your spouse but not you, then yeah, they probably have made effective service. But you do want to double check the laws in your state. And what you're going to be able to look for there in your state is the rules of civil procedure. And the rules of civil procedure are going to govern, everything that has to do with the lawsuit. And the rules of civil procedure in your state are going to have, guidelines for what can and can be adequate service. So I guess the answer to the question is yes, probably if your spouse has been served on behalf of you, then yeah, probably you have been served. But, again, double check the rules of civil procedure in your state. Okay, next question here. I sent a letter for debt validation to the debt collector, and they sent back a credit card statement. Is a credit card statement valid debt validation? Now, this is a little bit of a tricky question, and I don't know that I have an exact answer for you, and you'll find that, on a lot of this stuff, it's kind of, well, it depends. That's a common lawyer answer there. The Fair Debt Collection Practices Act, which requires debt validation if you ask for it, meaning if a debt collector contacts you, you can say, look, before you do anything else, before you contact me again, you have to validate this debt, meaning you have to send me some kind of proof that I owe this debt and that you have the right to contact me about it. And, so you send that letter off, and then you get back, they just send a bunch of credit card statements. Now, is that valid debt validation? Now, the debt collector is probably going to say, yeah, that's valid debt validation because I've got your credit card statements here that show that you owe the debt. But, credit card statements alone aren't necessarily going to be enough to show that there was a contract there, because probably when you got that credit card, you signed a credit card agreement. You had to sign something before you racked up all those charges. So, I would certainly argue in the court that no, that it's not valid debt validation, although it's probably part of it. So to me, if they're going to validate the debt, they've got to prove first the existence of a contract. That means the original credit card agreement. But second, that there have been charges under that credit card. That's going to be the credit card statement. And then third, if it's a third-party debt collector, they're going to need to provide some proof that there's a contract between the original credit card company and the debt collector. So sort of those three things. Now, all that being said, that's certainly the argument I would make, is that no, it's not valid debt validation. But the Fair Debt Collection Practices Act isn't necessarily clear on that topic. So, they're going to say that it is valid debt validation. And, that's maybe something for a court to decide. If you're going to decide to sue them for a violation of the Fair Debt Collection Practices Act, or if they've sued you and you want to argue, well, they haven't given debt validation, then you can certainly make that argument. And, I don't know how your judge is going to come down on that. I could see it going either way, honestly. But if you've been sued and you make that argument, you can make more than just, oh, well, they haven't validated the debt, because at the end of the day, at a trial, they have to prove, number one, that you owe the debt, and number two, that they have the right to collect on it. And in order to do that, they're going to have to show that original agreement. So, don't get too caught up on the debt validation stuff. I think a lot of people I talk to, they get so caught up on the debt validation. Debt validation is just a way to slow them down and get rid of some frivolous cases. But, so think more about, well, what are they going to have to prove in court? So maybe they'll throw something cheap out there like this for a debt validation, and you're like, well, that's not enough. Fine. They sue you. They're going to have to produce more if they're going to have a successful lawsuit against you for that debt. So don't get too caught up again on the debt validation there. So next question here, is $10,000 considered a small debt? So I guess this question is in response to my earlier video about arbitration. So again, what I typically recommend to people is, if you've got a small debt, you want to, and you've got an arbitration agreement in your original contract, you want to file a motion to compel arbitration, because the judge will then dismiss the case out of court and require the parties to settle this dispute in arbitration. The problem with arbitration for the debt collector is it can be expensive, because you've got to pay an arbitrator that's basically acting as a private judge, or a panel of arbitrators even. So there's a lot of costs involved with that. So if you've got a small debt, it really doesn't make sense for a debt collector to try and collect against you, because they're going to spend so much more in costs than they're going to recoup. So, it's not really a financially wise decision in that way. So, again, with small debts, this can be a really good tactic, because the debt collector will just walk away from the debt and you're free, don't have to pay. Now, so I guess the question is, well, what's a small debt? Is $10,000 a small debt? $10,000 is probably on the edge of higher, honestly, because if you think about, well, what's an arbitrator going to cost, and maybe they're $250 to $500 an hour, and you're going to take 4 hours to do an arbitration. Maybe they've got to do a little work up front, the arbitrator, getting the arbitration set up and things like that. So maybe you're talking $2,000 to $5,000, on the cheap side for an arbitration. Just a real simple case where the arbitrator's not really doing a lot of work. So you're talking about like small debts, like $1,000, $2,000. Like, yeah, this is a good approach and could work. $10,000, you're looking at the point where, well, I don't know, maybe. So let's assume it's even going to be a real cheap arbitration. Let's just go $2,000. You're going to have an arbitrator, it's going to cost to pay an arbitrator. And you've got a $10,000 debt. And let's say they feel pretty confident about being able to get a judgment for the $10,000. Now, debt collector or the debt collector's attorney is going to take probably a third of that. So if you've got a $10,000 debt, they're going to take about $3,300 as their fee, plus the cost of the arbitration, we'll say $2,000 as their share. So that's $5,000, which leaves $5,000 to collect on. Now, again, that's, being real, they're not spending a lot of time or effort or money chasing this money down. So probably best case scenario, the debt collector is probably netting $5,000 there. Again, that assumes everything goes well. They don't have a lot of costs. The arbitration isn't expensive, whatever. So you're looking at like, okay, yeah, maybe is worth it. But, maybe there's a lot more costs involved, or maybe it's going to take a lot of time. Maybe you're going to fight them a lot. That's just going to cut into that $5,000. So, $10,000, you've got to weigh and decide, how confident am I that they're not going to go to arbitration if I file a motion to compel arbitration? Because a motion to compel arbitration is not a get out of jail free card. A motion to compel arbitration, it really only says, hey, judge, you've got to kick this case out of court so that it can be arbitrated. It is not a guaranteed win. It's just that the strategy is, well, we think we can make it financially not worth their while to collect. That's why we do it. So the higher that number goes, the more likely it is that they're going to go ahead and arbitrate. And so your motion to compel arbitration strategy doesn't necessarily work. So $10,000 probably on the higher side there, or at least leaning towards the higher side where maybe it won't work. There's a couple other considerations you need to take into account on arbitration. And that is, a lot of times, you've got to split the cost of arbitration. So if it's a $5,000 cost of arbitration, you've got to pay half of that. That'd be $2,500. So, you file a motion to compel arbitration and they go ahead with it, you might be on the hook for another $2,500 to pay the arbitrator. Likewise, I've seen arbitration agreements where it's like the losing party pays the full cost. So you go to arbitration and you lose with that $10,000, and then it's a $5,000 arbitration cost. Now you've got a judgment for $10,000 plus the $5,000 arbitration cost plus interest. I mean, all of a sudden you're $20,000 this day is. So you just have to weigh those kind of things. How confident am I? If they send you a solid debt validation response and it's a big debt, motion to compel arbitration maybe isn't going to work there, because you could end up being on the hook for a lot more money. But again, if you're talking like $1,000, $1,500, $2,000, this is usually a pretty good strategy and works for a lot of people. So, okay, next question. What happens if you agree to a settlement, but then you don't pay? Okay, so here's how this works. You've got a debt and you reach out and you're like, hey, let's do a payment plan. And maybe you owe $10,000, but we'll agree that I'm going to make $1,000 a month payment for the next 5 months till we hit $5,000, and then they're going to write off the rest. So what you'll have going on there is they're not just going to just take your word for it, right? They're going to make you put that in writing, and you're going to have to sign it. And frankly, you want it in writing too, right? So, you've reached this agreement because what do you want in exchange? Once you make those $5,000 payments, you want them to dismiss the case against you with prejudice so that they can't sue you again for the rest. And you don't want them to say at the end, after you've paid $5,000, like, well, you owe us 5 more, right? You need it in writing so that no, I'm not paying you $5,000 more. We've got an agreement. You can show that to a judge, right? So now this can play out a couple of ways. First of all, some debt collectors, they're going to say, no, I'm not going to dismiss the case until you make all of the payments. And they'll ask the judge by filing a motion to sort of set this up so that so that they'll put the case on hold, and then as soon as you make all the payments, they'll file the motion to dismiss, the case is over. But if you miss a payment, they're going to go back to the judge and say, hey, they haven't upheld their part of the bargain, enter a judgment against them. The other way this can play out is maybe you can convince them, hey, I'll make these payments, but you've got to dismiss the case now. You've negotiated that. So they dismiss the case. You make 3 of your payments. You don't make the 4th and 5th payment. Well, what they've got now is they've got that written settlement agreement. So they're going to now file a new lawsuit against you for breach of contract, which is you've breached your settlement agreement. and that's going to be a real easy case for them. That's the problem, is you've got this contract that's signed by them, it's signed by you, that you've got to make these 5 payments. And honestly, the old debt doesn't even matter now, right? So you can be like, oh, well, they didn't have the credit card agreement, or they didn't have adequate documentation, or it was past the statute of limitations. Like, none of that matters, because you've got a new contract for $5,000. And if you do not make those final 2 payments, that is so easy for them to obtain a judgment. There's going to be no argument you're going to be able to make to defeat that if you've got the settlement agreement there. So, that's what happens, whether the case is already dismissed and they file a new case, or whether the case is still there and it's just on hold until you make all those payments. They just turn right around and they get a judgment right away for the rest of that money. And part of this has got to be, how are you negotiating this? Like, you've got a $10,000 debt, but you've agreed to pay $5,000 at $1,000 payments, but maybe there's like an escalator clause in there, like, okay, but if you don't make these 5 payments, then you owe the full $10,000. This is all going to be part of your negotiation when you're trying to reach a settlement agreement. So, that's the kind of thing that you want to be aware of. So, I always tell people, do not enter into a settlement agreement that you do not think you're going to be able to pay. That is the worst thing you could do. So you've got to go into your settlement negotiation with a pretty solid budget, knowing what you can and can't afford. And honestly, sometimes you are better off just getting a judgment against you than you are reaching a settlement agreement that you can't pay. That can get you into a lot of trouble. It's going to make it so easy for the debt collector to get a judgment against you and come after you. So, well, I think that's all the questions we have now. Just wanted to keep it short and sweet for today. Again, if you've been sued by a debt collector, I've got a ton of resources to help you at debtbrief.com. Obviously, here on the YouTube page, I'm trying to put out videos here that are free for you to access to help you learn what you need to do and what you need to say and how you need to approach your interactions with the debt collector, how to prepare for court, those kind of things. Those resources, I'm trying to get as much out there as free as I can. Also, debtbrief.com/blog. We try and put out some blog posts with the similar kind of content as well. If you need a little more help, head to debtbrief.com/shop, and we sell a bunch of forms there that you can use. If you don't have a lawyer, you can't afford a lawyer, it doesn't make sense to pay a lawyer because it's a small debt, it can make a lot of sense to handle this on your own. So there at the shop, we've got a bunch of different forms for sale. I do have a motion to compel arbitration. You want to know how to draft that? I've got one. You just fill out the form, file it. It's real simple. I've got a basic forms set. So if you get sued by a debt collector, it's a set of 10 forms, comes with an ebook with instructions on how to handle your case. And these are 10 common forms that are used in pretty much every debt collection lawsuit. So, you can purchase those at only $9.99 right now. So, it's a pretty good deal. It's a pretty cheap way to defend yourself. Got some other things like a debt settlement offer letter and settlement agreement. So like we're talking about negotiating a settlement, and if you do that, you're going to want to make sure you get that in writing. I've got a settlement agreement, a form that's up there for sale that is drafted in a way that is beneficial to debtors, because debt collectors, they've got their forms and you sign that stuff and that's very favorable to them, but you need something that is going to help you. There's provisions there and things that you might not even think of that you're going to be able to negotiate for because you've got that form. Likewise, if you're in the case, you want to send some discovery requests, I've got a packet there for sale with 107 different discovery requests that you can send a debt collector to win your debt collection case. That's a real great resource. People have had a lot of success using those, sending those off to the debt collector, and then they win their debt collection case. So finally, if you need some more help, sign up for a time to meet with me. You can just shoot me a message or head to the website, sign up there with the live course form. That's debtbrief.com/live-course. Just send me a message there and we'll set up a time for you and I to meet over a video call here where I will teach you how to defend a debt collection case without a lawyer. So I'll walk through the whole process from how do you respond to the summons, how do you send out the discovery? How do you respond to the discovery? How do you avoid getting a default judgment or a summary judgment? How do you get the case thrown out? How do you negotiate a favorable settlement? How do you document that favorable settlement? And then finally, how do you try the case if you're going to take this all the way to trial and beat your debt collectors? If you sign up for that with me, it's usually a 1 hour call there. Right now, I'm charging $125 for that call for at least limited time. And what you can do there is sign up, and I will include all of the forms that I sell is included in that charge. I'll teach you how to use all of them, and I'll give them all to you. So you can use those and beat your debt collector. We've had a lot of success with a lot of people doing this. So really looking forward to meeting with anybody that wants to do that, needs a little bit more help. So again, any help that you need, head to debtbrief.com and